Good morning, and thank you for joining us today. My name is Ajay Shamdasani, and I'll be the moderator of today's FATCA session. Before we begin, just a few housekeeping tips. The webcast audio is being broadcast to your PC via your PC speakers. So if you're having any audio issues, please verify that the volume's adjusted appropriately, and should you wish, a telephone dial-in facility is also available for the webcast. If you'd like to dial in, please select the telephone icon and you'll receive dial-in details. A Q&A session's planned for the presentation. We encourage you to submit your questions as they come in, and we'll try to get to as many questions within the 60 minutes as possible. To submit a question, just type into the WebEx Q&A window in the participant panel. If that's not visible, click on the question mark icon in the floating panel, and the question and answer window will appear. We'll make this presentation available following the webcast. Please look out for an email in your inbox with a link to the presentation and webcast recording within the coming week. If you're experiencing any difficulties, please don't hesitate to contact us on the chat facility, and we'll do our best to assist. Our speakers today are David Weisner of Citi and Karl Egbert of Dechert in Hong Kong. They're both rather esteemed, and I'm not going to belabor their details. Those are available. They're going to deliver presentations regarding FATCA, Inter-governmental agreements, and and the state of play regarding regional FATCA compliance. So without further ado, I'll turn over to Karl.
FATCA is such a big, complex law, and we've all heard about it so many times that I think sometimes it's helpful to just start by simplifying it down to its core. So I'm going to start by talking about basic FATCA rules, and then we'll move on to how these intergovernmental agreements affect those basic rules. And because we're all in businesses where clients, investors, or account holders are going to be affected by FATCA, I think it's best to just boil FATCA down to one question. What does FATCA look like from an account holder's perspective? Well, there's really four things you have to do in FATCA that will affect your account holders. One, if you're a foreign financial institution, an FFI, you have to gather information from your account holders. Now, you're supposed to use that information to do two things. A, identify your U.S. account holders, and B, identify people that you need to withhold against. That's basically any account holders who are non-compliant FFIs or recalcitrant shareholders who don't provide you with enough information to classify them as non-U.S. account holders. Once you've done that process, you move to step two, and step two is you start withholding against those non-compliant FFIs or those recalcitrant account holders. And then three, at some point, and this is under the basic FATCA regulations, not the IGAs, you have to close accounts that belong to those recalcitrant shareholders. And four, finally, you've got to report the information you've gathered, generally about your U.S. account holders, to the IRS, the U.S. Internal Revenue Service. Now, also you do need to register. If you're an FFI, you need to register with the IRS. And all of your affiliates eventually need to register with the IRS. If they don't, it will jeopardize your own FATCA compliance status. So that's a very basic description of FATCA, but even with this basic high-level description of FATCA, you can see how FATCA creates problems outside of the U.S. In Japan, there were doubts about whether withholding, particularly the pass-through payment withholding, would be permitted at all under local law. Insurance companies everywhere are trying to figure out how they can close accounts if they're required to under FATCA, because they are, by contract, bound to keep those open. In fact, it's the whole point of insurance. Jurisdictions all across Asia have had privacy and data protection laws that slam right up against FATCA's information reporting requirements. Now, usually your account holders can consent to FATCA reporting, but in some areas, like Hong Kong's mandatory provident funds, it's simply not legal for a manager to report mandatory provident fund information to outsiders. Still, other countries arguably have laws that forbid disclosure of any information to foreign governments, as PRC banking regulations arguably do. So there are a number of problems with FATCA and local law. So what's the solution? Next slide, please. Thanks. So the solution is the Inter-governmental Agreement. These local law conflicts aren't just made up by industry participants who don't want to implement FATCA. The conflicts are very real, so the U.S. Treasury realized fairly early in this process that they needed to get buy-in from local governments, or FATCA was not going to happen at all. And so in early 2012, the U.S. and 5 European jurisdictions announced an intention to negotiate intergovernmental agreements. And these agreements work like this. The basic benefit of these agreements is that the U.S. largely eliminates withholding against FFIs in IGA jurisdictions. A secondary benefit is that you can try to exempt your local FFIs from FATCA, particularly where there are pension or sovereign entities that aren't quite covered by the basic FATCA rule exemptions. But in return, the local jurisdictions make FATCA the law of the land. Sometimes people ask, how on earth can the U.S. do this? How can they pass all of these laws? How do they have jurisdiction over me? Well, the short answer is they don't. But IGAs essentially import FATCA into local law. And I'd say actually that this has far more benefits than downsides, but there are downsides. So instead of IRS requirements to do due diligence, reporting, and withholding, you will instead, in an IGA jurisdiction, have local law requirements that perform almost exactly the same things. But because these are now local law requirements, this one little trick resolves many, but not all, of the local law conflicts. Next slide, please. Now we're going to get a little bit deeper into what the IGAs look like and the different ways they work. Now, you might have heard there are 2 versions of the IGA, Model 1 and Model 2. I actually say there are 2.5 versions, but I'll explain that in a minute. The key difference is that in Model 1, you have to report directly to your local revenue authority. You report all of your FATCA information to your local IRD or whoever they are. You probably never have to deal with the IRS at all in Model 1, and as an American taxpayer, I can tell you that that is a gift that should not be underestimated. Under Model 2, you will need to report directly to the IRS. Your local government may still provide information to the IRS, and this information will generally be done only upon request, but under the Model 2 IGA, the IRS actually has a fairly broad authority to make group requests of information. Now, when I said there are 2.5 versions, that's because there are reciprocal and non-reciprocal versions of Model 1. In the reciprocal version, the local government reports all of the U.S. FATCA information to the United States. But the U.S. also agrees to provide information about the U.S. accounts of local account holders. Now, this reciprocal exchange of information is very interesting to governments that are short on revenue, which is basically everyone these days. And they might think maybe that some of their local money is hiding offshore in U.S. accounts. If there are a lot of these reciprocal agreements, and we'll talk a little bit more about how many IGAs there are later, there will be radical transparency for where people put their money offshore. The effect of that transparency could be massive movements of capital, either to jurisdictions without that transparency or back onshore in order to avoid tax penalties. But there's just one problem with this scenario, this reciprocal Model 1 IGA. Even though the U.S. is offering transparency to non-U.S. governments, it can't actually deliver. Even though the U.S. has passed FATCA, essentially legislating U.S. tax law for the entire world, there isn't a single law in the U.S. that says that U.S. financial institutions need to collect and provide FATCA-like information. So the U.S. still has some work of its own to do if it's going to implement these reciprocal Model 1 IGAs. Next slide, please. So let's go back to that opening slide. How do IGAs change things? Well, IGAs don't really change the first real step for most FFIs. FFIs in Model 1, Model 2, or non-IGA jurisdictions, they all need to register with the IRS. It's true FFIs in Model 1 jurisdictions don't need to enter into what's called an FFI agreement, which is an agreement with the IRS where they essentially agree to all of FATCA's requirements, but that's just because in Model 1 jurisdictions, as I mentioned before, FATCA has become law of the land. There's no need for a separate agreement. And those FFI agreements are not that big of a deal anyway in terms of what kind of process you need to follow. I also mentioned that you and all of your affiliates, your expanded affiliated group, have to register or be FATCA compliant, or none of you will be FATCA compliant. Well, the IGAs offer a little bit of relief for that. Under the regular FATCA regulations, you're allowed a sort of a grandfathering period where not every affiliated FFI needs to be compliant, subject to certain conditions. Under the IGAs, there is no grandfathering period, but you're allowed that relief indefinitely. In other words, if you have an affiliate in some jurisdiction where FATCA is simply not possible, you are allowed to register as an FFI and be compliant as an FFI indefinitely, even though your affiliate in that other jurisdiction cannot. There are terms and conditions to that, though, so you need to make sure that those are available to you. The IGAs also resolve most of those local law conflicts. Now, they don't resolve everything. If you are in a jurisdiction where FATCA reporting requirements require consent of account holders, then you still need to figure out a way to obtain that consent. Another fallout benefit of the IGAs is that resident FFIs are not subject to withholding, but also they're not required to withhold against other resident FFIs or recalcitrant shareholders. And that's a big benefit. Now, it's true that in Model 2 jurisdictions, you may eventually be required to withhold against recalcitrant shareholders. But kind of the basic scenario is that you really don't need to do much withholding if you're in an IGA jurisdiction, at least not against local people and local entities. So once these IGAs are implemented, and there are a bunch of them in many jurisdictions, it could be that the amount of withholding you have to do is sharply limited. And that's going to be of great benefit because withholding is one of the most difficult things to do in terms of infrastructure if you don't already have it. So that's a brief idea of how IGAs work. And with that, I'm going to turn it over to Desmond and David to talk about how far extended IGAs have become.
Thanks, Karl. This is Desmond from EY. What we are going to do for the next 10 to 15 minutes is to actually have a snapshot on the progression of FATCA in the last 2 years. In addition to that, we are offering a snapshot on Asia Pacific with regards to IGA, the landscape involved. And thirdly, we will focus a little bit more on the Model 1 IGA, which has been announced for Singapore, and what does that mean for financial institutions based in Singapore itself. So if we are to look at the first slide that we have, which shows a snapshot on the progression of FATCA itself. Since 2010, where FATCA was first introduced to financial services industry, there's been significant progress made. Among others, the industry and authorities are accepting FATCA and starting to plan as well as execute on its implementation. There's a release of final regulations in February 2012, and there's an extension of FATCA timeline. But more importantly, an observation is the increasing acceptance and focus by the governments around the world on a possible IGA, as illustrated in Step 2A. And our pulse on the ground indicates that this should be gaining momentum. And the negotiations for IGA is probably one of several reasons, among others, for extending the FATCA timeline. My fellow panelist, Karl, has shared on what IGA is, and David will be sharing shortly on the intricacies of IGA and practical considerations. Nevertheless, I wanted to just put in context the objectives of IGA, which is one, to resolve the legal impediments to compliance in the partner countries, two, find simpler, more practical implementation options, three, reduce cost of compliance for FFIs. But it's interesting to note that while FATCA started as a US legislation, is now finding its way into domestic legislation and becoming more a domestic compliance requirement. Also, being in an IGA jurisdiction in itself is not a silver bullet for FATCA purposes. Among other considerations, the IGA is territorial, meaning it's applicable only in a jurisdiction where the entity is based. If you have branches or entities in other jurisdictions, you will need to consider if those jurisdictions are also IGA jurisdictions. In addition, it needs to be considered whether the IGA that is to be adopted is a Model 1 IGA or Model 2 IGA, as Karl was sharing earlier. And even if it's the same Model IGA that's adopted for the various jurisdictions that the entities operate in, the planning, implementation, and operationalizing of FATCA and IGAs need to take into account the differences of the annexure of these IGA jurisdictions. Having said all of that, we still see the trend of leaning towards IGAs as an overall favorable development. And if we could turn to the next slide, we have captured a snapshot of the Asia-Pacific countries and where the select Asia-Pacific countries stand in terms of IGA with the Treasury. As background, the US Treasury announced in 2012 that it is engaged with more than 50 countries and jurisdictions around the world to improve international tax compliance and to implement FATCA. This is through the establishing of a common intergovernmental approach to combating tax evasion. And to date, we understand a number of jurisdictions is closer to 70. In that announcement, the Treasury Department has mentioned jurisdictions that are engaged in various stages of discussions regarding IGA, and this has been broadly placed into three bands. The first band are those that already concluded a bilateral agreement or in the process of finalizing an IGA. The second band are those actively engaged in a dialogue towards concluding an IGA, and where the Treasury expects to be able to conclude negotiations with several of these jurisdictions by end 2012. And the third band are those working with Treasury to explore options for IGA. So on this slide, what we have done is that we have identified the Asia-Pacific jurisdictions mentioned by the IRS and tracked their progress since 2012. And with that, there are a few key observations. One, the progress within Asia-Pacific is not necessarily a marked contrast to the rest of the world. It has been more a progression rather than a race to the finish line for IGA negotiations. Australia and Singapore have put ahead from the pack in terms of making progress on IGAs. Singapore is the first ASEAN country to indicate intention to enter into a Model 1 IGA, and it remains to be seen if this will have any influence on the rest of its ASEAN neighbors or its friendly rival Hong Kong. There are a number of other key Asia-Pacific jurisdictions such as China, Vietnam, Thailand, Indonesia that were not named in the IRS announcement and have also not made any official announcements yet on whether they will or will not negotiate for an IGA or for that matter the model IGA that they might actually adopt. Having said all of this, the table only tells half the story as a number of these jurisdictions may or are already engaging the Treasury on discussions by keeping their cards close to their hearts. Industry feedback regarding IGAs is also gaining ground as a number of the authorities in these local jurisdictions try to get a feel on the pulse on the ground and also get a handle on how the different IGA models may work for the financial institutions based in their jurisdictions. Overall, based on our interactions with authorities, the industry and industry bodies internationally and regionally, our sense is that the Model 1 IGA seems to be gaining favor internationally compared to Model 2 IGA, though there may be the occasional Model 2 IGA that may be popping up within Asia Pacific. At this juncture, David and Karl, as active members of the international FATCA community, what are your observations on developments of IGAs in the region? Any thoughts?
Speaking, and I kind of second what you were saying. Asia's not necessarily far behind the rest of the world, but there are a number of jurisdictions where you would expect IGAs to be done, and they're not quite done yet. I've noticed that there's a number of questions about what the status in Hong Kong is. We do have official word from the government that the Hong Kong government is looking at a Model 2 IGA, but we also know that the negotiations have not quite progressed to the point where the Hong Kong government is ready to put itself on the list of governments that are actively pursuing an IGA. We know the negotiations are ongoing, but it's a little bit of a black box exactly where they stand, other than their official statement that they are looking at a Model 2 IGA. I think, though, there's not much that's stopping Hong Kong from entering into a Model 2 IGA other than the fact that they would very much like to get the Hong Kong state-sponsored, employer-sponsored pension plans, the MPFs, exempted. That is something that they've said is a major priority, but that may not be possible. So I know they're very concerned about that, and if they can't get that, then they may question whether there's a reason to enter into a Model 2 IGA. If you're a Hong Kong institution or an institution with a Hong Kong branch and trying to decide what to do, I think maybe David is going to have a pretty interesting insight into that. So I'll cede the floor to him.
Yeah, I think that it's thanks, Karl. I think that also with Hong Kong, you have to think about the thought process here. Most of the FIs here are global in nature, right? And so usually in a lot of this IGA process, what we've seen in the bank is that the country, let's say the Ministry of Finance, will reach out to the local banking association and they'll ask, what is your thoughts on FATCA? What type of model would be good? And what are your concerns that, in the Annex 2, where we can put down potentially exempt beneficial owners, what would be good carve-outs? For example, are there local banks that really shouldn't be caught up in FATCA because they truly are local in nature? And in Hong Kong, it's a little bit different than we're seeing in other countries because in Hong Kong, there's really only a few local players. If you think of Hong Kong as a financial center, so they're more sophisticated. Whereas what we're finding in banking associations, in conversations we had in China, the Chinese authorities, the CBRC, the bank regulators, are concerned about rural finance companies really getting caught up in the FATCA web, and their approach to getting a IGA will reflect their needs to probably see that those finance companies are excluded on Annex 2 as exempt beneficial owners or deemed compliant. So I think that every country has its own motivation for that. What we're seeing, certainly, Desmond has that list of, he writes China and Hong Kong, Thailand, Indonesia. There's certainly, Indonesian has announced publicly to the banking associations they want to pursue a Model 1. We've also seen China reach out to the banking association to get their feedback, and the banking association has indicated they would preference for a Model 1. In Thailand, there's been multiple seminars with the government encouraging the Thai government to move forward with an IGA. So I do think that across Asia we are seeing significant momentum. But Karl mentioned it before. The problem is a lot of this stuff is kept confidential, right? So we'll often hear from the Asia side they want to go forward. Sometimes we even hear that they are talking to Treasury, they'll tell us, but where they are in a negotiation process, we don't know. And why is that a problem? The problem is because an IGA is only effective if it's signed, right? So it's not good enough to know that, hey, Indonesia is talking to Treasury right now. That's not good enough for me. For me to act on as an FFI, I have to have a signed IGA, and that's unfortunate because I don't know when that signed IGA is going to occur. So that's a problem sometimes at FFIs that we're going to have. IGAs are great, but until it's signed, you really can't act on it. So back to you, Desmond, for the rest of this. The rest
Actually,
of
we just had one other question on which jurisdictions, and I noted that someone asked whether Taiwan would be trying to enter into an IGA. They have announced that they've reached an understanding with the U.S., so I would include Taiwan on the list of jurisdictions that it is actively exploring an IGA.
I would agree. Taiwan has told the Banking Association they will pursue it. I think for some reason, and I don't know if in a lot of this is also you get into rumors as well. We had heard someone in Taiwan say to us that perhaps they're going to wait till China to do IGA, then Taiwan would do it, but that might just be, rumors, fact or rumors. But, Taiwan does want to do an IGA. I think that there you do have a lot of people Taiwanese banks who don't want to establish a relationship with the IRS, so they might be interested in Model 1 because this way they don't have to have that type of relationship and they can just stick, just deal regularly with the Taiwanese regularly like they have been. We have a question that says, Model 1 IGA, do you need a responsible officer? I would think you do. Karl, I don't know if you have any thoughts on it, but I thought even under Model 1, you'd still need to have an RO for your FIs.
Actually, that is another benefit of it.
Is that?
It's a benefit, under quotes, of the Model 1 is that you do not need to designate a responsible officer. But it's sort of a Pyrrhic victory in that, you don't actually need to designate a responsible officer, and that resolves a lot of internal problems you can have with playing that game of hot potato. But basically everybody is on the hook under local law. Anybody who could be on the hook under local law is going to be on the hook. So you don't have one responsible officer, but you do have a number of people who, depending on what the local rules are, could be responsible.
Well, because I will say that even if we don't have to, I think we'll still, as an FI, appoint responsible officers because we still want one person interfacing with the government, even the local government at that point. From a corporate governance structure, it still makes it easier for us, even if it's not required.
Okay, thanks, David and Karl. I guess we all remain hopeful that the momentum for IGA continues, and we will be seeing more official announcements from the various governments with regards to their intentions on IGAs, the models that they are looking at, and as this should facilitate the planning for financial institutions in these jurisdictions. Maybe what I'll do is that I'll spend the next couple of minutes looking at the next slide itself, with a bit of more focus on the Model 1 IGA for Singapore, and also a broader development before I hand over to David to share more on the practical considerations for the IGA. So with the announcement of the IGA for Singapore, it was not a surprise as Singapore has previously indicated its intentions to significantly strengthen its framework for international cooperation to combat cross-border tax offences. And this has taken the form of a holistic suite of key steps to further strengthen the EOI framework. Mainly, this is extending the EOI assistance in accordance with standards to all existing tax treaties, meaning to say that this standard will now apply to tax treaties as long as there's reciprocity with regards to the tax treaty. Singapore is signed up to the Convention on Mutual Administrative Assistance in Tax Matters. Key significance to that is that it expands Singapore's network of EOI partners by 11 jurisdictions, and of significance that then brings into the net US and Brazil in order to share information. So these two changes taken together doubles the number of jurisdictions to more than 80 that Singapore will be able to exchange information with. The IRAS, the Singapore Tax Authorities, would be able to obtain bank and trust information from financial institutions without having to seek a court order. They will, however, continue to assess whether the EOI requests are in line with the standard, and taxpayers will continue to have the right of appeal. And last but not least, the introduction of the announcement with regards to Model 1 IGA for Singapore. So Singapore has made a commitment to make legislative amendments necessary to effect the above changes before end 2013. And if anybody on this call is to know Singapore, the Singapore government tends to deliver on their promise. So this is going to be key in providing certainty for Singapore-based financial institutions with regards to FATCA, and more specifically with regards to the IGA that they have committed to. It's also important to note that with effect from 1st January 2013, Singapore will consider the laundering of proceeds from serious tax crimes as part of the AML provisions. It has also embarked on an exercise to gather information on high tax risk accounts. And we have really been assisting a number of our banking and fund management clients on phase 1 of such an exercise. But if we are to look at the Model 1 IGA itself and the announcement by the Singapore authorities and how early it's actually been made, the intention is really to help Singapore-based financial institutions with FATCA planning and implementation. And while details on the Annex 1 and 2 of the Singapore Model 1 IGA are still being hammered out, FI can at least, in the interim, take some guidance from the other Model 1 IGAs on what may be expected, and this has helped financial institutions with their planning and implementation of FATCA. In making the decision to adopt Model 1 IGA, the authorities have actually sought detailed feedback from industry and practitioners, and this is a strong testimony to the Singapore pro-business environment and demonstrates the commitment to the financial services industry. So this should actually enhance Singapore's status as a well-established financial center and also the expanding asset management hub, putting Singapore on par with the key financial centers of London and the leading fund management hubs in the Cayman Islands and Luxembourg, and may hopefully give a legs up to Singapore in the competition for attracting investment funds to locate Singapore compared to, say, Mauritius. Maybe what I should do is that I should hand over to my fellow panelist, David, to share more on some of these practical considerations of the IGA. David?
Okay, thank you. I'll also be talking about, if we could just turn to the next slide, the first slide, the next slide, thank you. I'm going to talk about IGAs as well as non-IGAs in terms of what I'm going to talk about today is, okay, if you're an FI, what do you need to start thinking about? What are the issues that, I'm seeing and where I'm sitting? Okay, so this is an illustration of what happens if a bank doesn't comply with FATCA. I think most people on the phone get that. Currently you invest in U.S. securities. If there is, under current law, there's no withholding. If FATCA kicks in, you're not compliant, there's a 30% withholding. Gross proceeds 2017, you go to sell your securities, and I'm using example $2,000, it's 30%, you're going to get hit with a withholding at $600. So let's put this also in an IGA context, because one of the things an FI has to think about is who up their chain is going to be compliant or not. So even if you're in Singapore and they sign a Model 1, and that's wonderful, they'll do that. If it turns out that, that above the bank that says FFI, that's your bank, you're a Singaporean bank, and you're going through a bank in a European country, or maybe you're going through some other intermediary, and that intermediary is not FATCA compliant, it doesn't matter that you're an IGA country, your intermediary isn't, if your intermediary is not compliant with FATCA, there could be FATCA withholding. So, I think it's important when even that you think that, IGA does a lot of nice stuff, that you start thinking about still your chain of payments to see how FATCA is going to impact you. And I think that's really important. And as I've said to many people when we talk about FATCA, it doesn't matter that maybe you don't have any U.S. people. It doesn't matter if this is for a prop desk or for your clients. The fact is that, if the bank or even upstream isn't compliant, then you're going to hit with the withholding tax. So I think you start analyzing your chain of payment. Let's go to the next slide. if we could turn to the next slide, please. Yeah. Okay, what is an FI? Why do I have this here? I mean, is because I think that, you as an FI need to start analyzing what FIs you have in your chain. When you start thinking about FATCA and what ones to register and what's applicable, you have to figure out what is it, what are FIs, what aren't. If, for example, there are special rules if you have a credit card company and it just is doing credit cards that are different than if you have, let's say, a bank entity and that bank is issuing credit cards. There's certain rules that on due diligence that are different you need to look at. You also need to look at in a particular legal, in your legal vehicle, for example, do you have non-FIs? Do you have an operations or a technology? Maybe you have a call center. You wouldn't have to register about that. And then another thing you should worry about, or actually not worry about, but actually think about is in an IGA does kick in, under Annex 2, they'll have certain carve-outs that might apply. Probably unlikely, but they may apply, and it's certainly worth it. If an IGA kicks in, does anything apply to you or your organizational chain? And it's important to think about that in that context. And it's also important to think about who you're interfacing with in clients and whether or not, are they FIs or not. And also for any of your MNC clients, they think FATCA doesn't apply to them, but they actually might have an FI on their chain, organization chain that they need to start thinking about. And so you might get questions from your clients whether or not, what your thoughts are. Please don't answer them. You don't want to provide tax advice, but you may see some clients coming to you not certain if they're an FI or not because of the nature of their business. A treasury center, something like that. What's the next? Please turn to the next slide. Okay. I'm going to sign up for FATCA. Great. Now the difference is if you have FATCA and you versus regular FATCA or FATCA with an IGA. An IGA you would just probably likely register, but if you don't have an IGA, that means you have to enter an agreement with the IRS. And a lot of the stuff people probably know about due diligence, withholding, reporting. But one of the things I want to point out is really the waiver and consent. So one of the things that you're going to have to do is you're going to have to make sure that your terms and conditions are such that you're able to be able to do all these different things. And even if also in terms of your FATCA solutioning, you might say, well, I have 6 FIs across Asia. Maybe it makes sense for me to have a hub that just looks at tax form validation as opposed to having it in all countries or maybe doing reporting. Can I outsource that information, right? So it's not just the information that's in the IRS, but it may be affecting your FATCA solutioning. You may have to think about, can you do that? And that's important. And typically, the reason you have IGAs is because they do help in preventing or help with the data privacy issues, and that you typically would have to report locally, and that's all good. But you have to make sure, if you have a situation where you actually have to withhold on a non-participating FFI, you're an IGA country, you make a payment to someone who's of U.S. source payments to a non-participating FFI in a non-IGA country, and you have to withhold. Can you do that? So you have to start thinking about in an IGA context, what's your relationship with FIs in non-IGA countries, and do your terms and conditions impact that? And also, the last bullet point is that it's really, you have to make sure everyone in your expanded group is compliant. If not, it could hurt your whole compliance in general. Let's turn to the next slide. On this one, I really, even though we're far along with FATCA, but I still really want to emphasize this because I want to talk about certain decisions in a tree in terms of, as an FI, what you need to start thinking about. So one of the things you have to do, regardless of whether you're an IGA or whether or not you're signing up with the IRS directly, is due diligence, right? You have to be able to determine who someone is for FATCA status, okay? So individual walks in, are they a U.S. person, are they a non-U.S. person, and what do I need to do? Now, a U.S. person, I get a W-9. A non-U.S. person, what do I need to do, right? Do I rely on KYC? Do I get a W-8 Ben? I think that people have to start thinking about what type of IRS forms are they going to use. So there's, on one hand, you have full compliance if you use an IRS form. Never have to worry about the correct classification. The form does it for me. That's perfect. On the other hand, clients may not speak English that well. Clients may not like the form. They may not understand it. It's hard for you to explain the form because you don't want to be in a situation where you're giving tax advice. And the client may say, come on, you know me, why do I even complete this? And so, on the other hand, if you do nothing, it's a great client experience. If you do everything, it may not be, but you have to ensure you're compliant. So we're in that, where in that line are you going to be? Where are you going to decide? And that's something that's difficult to do now, is because we're still waiting to find out what the final forms look like. But I think that as you think about due diligence, a lot of FIs need to think about where and what situations they're going to use a form, when are they not going to do a form, and also where will they allow exceptions, and also that will impact also what you do in IGA. And if I do sign an IGA, because maybe I will, maybe my standards can be different in an IGA country because I know that the other FIs I face off with will be compliant. So what will I do in those situations? And also with corporations, that's something we haven't talked about earlier today, but I think we all know that if you have a passive non-financial foreign entity and they have a substantial U.S. owner and it's passive, you have a reporting obligation. So how am I going to get that information? What do I need to get? And I think that if you're an FI, you need to start thinking through these type of decisions. And I can tell you, it's not easy because of all the different language issues that we have in Asia, and also just different client experiences. And like I said, there's a tension between the people who do compliance and a tension between the people who face off with the clients in terms of what they want to do. So things to think about. Turn to the next slide. And these are more things to think about, okay? And I don't have the answers, but as an FI, these are things that you need to start thinking about as well. And going through, for example, the first bullet point, it may be that you decide not to have certain products because, for example, you may find, some small institutions say, well, I do allow people to invest in U.S. Treasuries, but maybe I won't do that because I'm now investing in U.S. securities. It may be harder because my documentation standard might be higher, and I don't make that much money. It'd be easier for me not to do that business. So some people actually may think about that. Do I build something because I might have withholding? I don't want to build a withholding engine. That's too difficult. Onboarding. You're going to have situations where clients now are going to have to, get more information than typically you do, and the client's going to wonder why you're asking me this information when I've never had to worry about this before. And also, that's particularly true even in an IGA country because you're still doing due diligence, but your client might say, well, do we even have to worry about FATCA or, our country sign an IGA? I think there's going to be some misinformation. Some people, unfortunately, think if you sign an IGA, FATCA is done with, but you still have to do stuff, and your client may not realize that. So you still have to ask clients information that that typically you may have not had to worry about before. And also, you have to educate the people handling that as well, the relationship people, and reporting. Now, also, when we talk about waiver of privacy rights, well, if you have to do reporting in a non-IGA country, you have to make sure you have the terms and conditions allow you to do such, and also offboarding. Now, recalcitrant accounts, IGA is nice, and you don't have to really close in an IGA country, but there may be situations you're doing business in a non-IGA country where you have to start thinking about, do you actually have to close that account? And the last bullet point is one I mentioned before, and it's a really big discussion because it also might determine also business by business. For example, in a non-financial foreign entity, if they're publicly traded, I don't have to worry about it, right? I don't report on a publicly traded, even if it has a substantial U.S. owner. So, for example, Procter & Gamble Korea Limited, I wouldn't worry about it, even though it's 100% owned because it's publicly traded. It's affiliated of a publicly traded company. Now, maybe I send a form over and say, okay, P&G, fill out this W8BEN-E, check the box. And maybe P&G says, come on, Citi, you don't know we're publicly traded. You don't know we're affiliated of publicly traded. You don't have that information, And so you're going to get in these type of discussions with the client. And so I think you have to have a firm policy and think through under what circumstances you will need a firm, what you don't. And I keep on harping on this because I'm finding that's discussions I'm having internally, and it's a big tension. Next slide, please. I want to talk about briefly, go through a couple of quick slides just to highlight the impact you will have on transactional documentation in terms of what FATCA is going to impact. I mean, this is something that a lot of seminars and calls people haven't really focused on. They're all focused on other matters, but I think it's something that it's worth talking about. And I want to talk about first the ISDA. So in an ISDA right now, the way it works is there's a gross up. So if Citi pays DBS and there's a 20% withholding tax, they get 100. If they pay us and there's a 30% withholding tax, we get 100. So we're all on level playing field. People gross up. You don't pay net. You don't pay 80. You don't pay 70. You pay 100. FATCA kicks in. I now have to make a payment, but I have to withhold. Now, because my counterpart's not compliant with FATCA, I really should be giving him 70. It's not my fault he's not compliant, but now I have to give him 100 because of the nature of the gross up in ISDA. So what the protocol is trying to do, turn to the next slide, please, is basically carve it out. So if you see in the bold letters, it said, okay, we're going to gross up, but we're not going to gross up for FATCA. So it's not my fault, counterpart, you're not compliant with FATCA. We're going to give you 70. Every other tax comes in, I'm going to give you 100. FATCA, I'm going to give you 70. It's only fair because we're not on a level playing field. It's not my fault they not comply with FATCA. Because if not, it's going to be very expensive to do business. If I have to gross up for counterparts that aren't compliant. So IGs are helpful because I know that my FFIs on the counterparts are all going to be compliant. But in non-IGA countries or if I do business, cross border, I do have to worry about this. And so ISDA has this protocol, and by hearing the protocol in ISDA, if you sign up, all your previous ISDAs with all the other counterparts are deemed to could be considered that FATCA doesn't apply to the definition of identifiable tax. So so you might have counterparts come to you and say, can you sign up for the ISDA protocol? Or they might say, hey, let's amend this ISDA to get rid of FATCA. And I think that's a good thing. And this way, you're not going to be on the hook for grossing up on a payment counterpart because they're not compliant. Next slide, please. This is just an example. You'll see it in loan agreements. So if you're borrowing money, you may think about maybe carving out that you don't have to gross up on a payment back to a lender just because they're not compliant with FATCA. And there will be some other language put in the loan agreement. I'm not going to go into it, but I think you should be on the lookout. You probably will have it. The Loan and Market Association is having several riders, and the market hasn't really had a standard yet. In certain loan agreements, you'll see different riders. There still hasn't been one consistent policy, but it's something to be thinking on the lookout that in how the impact of FATCA will have on loan agreements. Next slide. And then the next slide, you'll see just briefly I put down offering memorandum. So you may find in offering memorandums might have FATCA language. Are you going to be compliant? The impact if you're selling through, let's say, depository like a CCAS or a Clearstream, what happens if they're not compliant? That might be in your offering memorandum. It may be that investors want to see that you disclose your FATCA status. And I'm sure that someone like Karl, who does a lot of offering memorandums, are probably seeing a lot of this in his work, and you'll see more to come on it and on it as well. So it's something to be considered if you're going to the capital markets and you're raising money, or if you're raising a new fund, you might find FATCA language that's going to be in there, and you might find that investors will actually start looking for it. So, that's something to think about. Next. Okay. Just briefly, the timelines. Now, why are we, the timelines are always important. Every FATCA seminar, you'll hear about the timelines. But I think that, as an FI, if I'm sitting in your shoes, I'm going to be worrying about what I'm doing for new accounts, and I'm going to be worrying about what I'm going to be doing for my registration and maybe withholding. I'm going to be less worried about reporting because I have a little bit more time. So when you think about your FATCA solution, and you should probably think about what's coming up, what do I really need to do more, what's coming up soon, and what can I wait a little bit. In terms of making my solution. Okay? And I think that's it for me on slide 2. Next slide. And I think that's it for us. I think at this point now, thanks for that. At this point now, I think we'll open the lines, AJ, and probably if you have any questions or anyone else has questions for the group, we can probably take them now.
Sure. Well, let's just kick off with one. Certainly in the circles I run in and the people I speak to locally, to go along the lines of what Karl said earlier, there has been some chatter that the Financial Services and Treasury Bureau has been in talks with the U.S. for an IGA for Hong Kong. I'm curious, David and Karl and Desmond, if you want to chime in. I'm curious as to whether or not you think China will acquiesce to the U.S.'s demands.
Yes.
Hong Kong probably will come around, but they've been more opaque than Hong Kong. Any thoughts on which mode they'll go and what the timeline will be?
Yeah, timeline I don't know, but I do know a couple things. I mean, I do know that when during industry meetings that I've been present at, the Chinese government is concerned, as I mentioned earlier, that certain small FIs will be caught up in FATCA. And if you think about China, right, you have like a couple large global institutions, but you have a lot of FIs that are really truly local entities, right? They're really they only do business in China. They only all of them. Their clients are Chinese. They don't even have an English name. And I think that the CBRC, the bank regulators, are concerned that those people, not get caught up. And that's where an IGA comes in, because perhaps in Annex 2, they can see to it that they'll qualify for a local bank exception, and they can be, perhaps not be, FATCA may not be applicable to them. And so I think that's a driver for them. I also think they don't like the idea that, that their institutions would have to deal with a foreign regulator. Their local institutions, not the Citibank China's. We're talking about the local FIs. And so when the banking association, China Banking Association, certainly has reached out to its members and asked them their thoughts on IGA. We've gone back to the Ministry of Finance, and they have said in meetings that they do want to pursue a Model 1, and they do want to go forward. Now, what's not clear is the timing. And it's also not clear, will China ask for other things? Treasury typically, it's really, and Karl can chime in, it's kind of take it or leave it. This is what they're going to sign. And I don't know if China's going to come in and say, well, we're different, we want something different, and how receptive Treasury would be for that. So, Karl, I don't know what your thoughts are on this.
Yeah, I think Treasury really has been take it or leave it. I mean, it's been very disappointing. When we have hoped that there were very good local reasons to get exemptions, Treasury hasn't necessarily been forthcoming. But if anybody is going to get the U.S. to make serious modifications to the IGA, it would be China. And maybe it won't necessarily be to the text of the agreement. Maybe the text of the agreement is going to look largely the same. But, there are other possibilities. China could ask for an expanded exclusion of sovereign entities and a different definition of sovereign entities. Because the sovereign exclusion in FATCA is actually pretty narrow. It mostly includes wholly state-owned enterprises. It wouldn't necessarily include a lot of the big Chinese banks that have state involvement but might be traded on a market or might be held elsewhere. And so I wonder if China is going to push for some exclusion of those, or some kind of exclusion that when you get down to the state holding companies, that the obligations of FATCA stop there. So I do think that there's a possibility for changes that are different from other jurisdictions, but it is just speculation. We have heard so many things, and they are conflicting, and they go in different directions.
Yeah.
About China's IGA that I have to emphasize. It is speculation at this point.
Yeah, and that's the thing is that we said earlier too, AJ. Like Karl and I, perhaps because we're so involved in FATCA, we always hear like different FATCA rumors, and some of it's stuff firsthand because of conversations we've had with the central bank. But then you're never privy to the actual negotiations, and you also don't know what was actually said in these negotiations, and where these things stand.
Okay. There's an ongoing bone of contention locally, and one of our attendees has raised it, which is that in the Hong Kong context, why is the MPF exemption such a big deal? Is it purely because of the data privacy issues under the local personal data privacy ordinance, or does it go beyond that? Your thoughts?
I would say it's a huge deal because it is Hong Kong's principal retirement planning vehicle. It is designed for people who work in Hong Kong and have ties to Hong Kong. And sort of U.S. regulation of that and U.S. withholding against a retirement vehicle that's relied upon by many is, I think, rightly viewed by Hong Kong as a pretty grievous encroachment on Hong Kong's rights to govern its own citizens. So I think they have said that FSTB has said that it's a major issue for them, and So that there are sovereignty concerns, and then there are also those legal concerns that without help, MPFs cannot comply with FATCA, and so there's some likelihood that some MPFs would be withheld against. I think that's just simply unacceptable for a jurisdiction's main retirement vehicle.
And also optically, think about it, that people aren't really hiding money in the MPF funds, right? So from a Hong Kong perspective, they would also think, well, we understand, what your objective is, U.S. Treasury, but, are people going, hiding their money there?
There were certainly hopes that the recently released FATCA implementation guidelines would have put the MPF issue to rest, but it from what people tell me locally, it seems to be lingering. Our next IGA question is rather novel in that some have heard rumors about a third way, a model other than Model 1 or Model 2. How true is it, and how different would it be?
Karl, you
Sorry,
want to
AJ, could you say that again?
Sure.
How different?
There's talk of another model other than Model 1 or Model 2 approach, and is there any truth to the veracity of those claims, and how different would a putative Model 3 be?
I have not heard that. I have heard of different Model 2s for countries that already have TIAs,
Yep.
tax exchange agreements, and ones that don't. So that's actually another 2.5 version. There are obviously the two versions of Model 1. I don't know what a third way would be.
Yeah, exactly, because I think that because the current models handle those situations, like, do you have a tax information exchange agreement? Do you not? Is it reciprocal? Is it not? So I'm with Karl that I don't know. I think 1 and 2 and the variations of 1 and 2 carry the various scenarios out there. I don't know what other scenario there would be.
This is Desmond here. At least from my perspective, I'll say that from the IRS, in their push towards trying to conclude as many IGAs as possible, I would have imagined that they would probably want to try to limit the kind of permutations and options that may be available out there. So I fully agree with Karl and David in that it's really a cost-benefit analysis that the IRS needs to actually strike in order to push towards April 2014.
Yeah. In the remaining time, AJ, there are some questions on the chats, and someone asked about should we in Indonesia be preparing for implementation? Will it impact Indonesia? Yes, of course it will. Whether or not, and more so, if Indonesia signs an IGA, then Indonesian government's going to say, hey, every FI in my country is going to be compliant. So, it affects all countries. And then another question asked, what's the status of the Japanese IGA? Well, the Japanese IGA has been signed. It's the only one in Asia that has been signed. That's a Model 2. We had someone else ask, is Taiwan negotiating an IGA? And as we said earlier, Taiwan has said that they aren't interested in doing an IGA, but we don't know where they are in the process.
They did release a statement that said that they had agreed in principle with the U.S., but again, there's nothing from the U.S. on it, and it can be difficult to know sometimes exactly what these statements mean.
Yeah. And then another question is about the template. The IRS, all these different templates, the different Model 1, Model 2 variation, IRS has its own templates, and if you can actually find them online. If you go to the Treasury website, we'll have it. And so so that's what we're talking about. Like the IRS will have a step template, and then it's very rare for them to offer. They wouldn't. It's more like we said, take it or leave it. It's more getting country specific on the Annex 2 and putting it down than it is making changes to the templates.
Okay. Any thoughts on the new FATCA online registry, which recently came online? In terms of how much of a benefit is that?
Well, it's great that they finally got around to doing it. Registration is the first step for everyone. I noticed that one of the questions in the queue was, do you really need to register in a Model 1 jurisdiction? The answer is yes, so far. It's at least theoretically possible that a Model 1 jurisdiction would allow you to not register, and they would come up with a local alternative. But no local alternatives have surfaced, so everyone's going to need to register, and so it really was the first step, and the IRS was supposed to get it done last month, and so they've kept their streak alive of being late with every single FATCA deadline. But it's great that it's online, and it is what everybody should be looking at right now, learning how to use that system and figuring out what it will mean to be registered.
And IRS has issued some videos, actually, that actually how-to videos to go on how you can register online. So they have a lot of information, and then the videos, certainly you can watch and share them with your family, because I think everyone will be interested in it. Also, the only thing to note about the registration is just when the GIN numbers will be issued. They won't be issued till probably past January 2014. So some FIs out there may not register immediately. They may wait till like third or fourth quarter, because since the GIN won't be issued till later.
Okay. Another question that we've got pertains to foreign banks. Do foreign bank branches follow the IGA that's been concluded where the branch is located or in the home country, as in a Chinese bank in Australia, for example? Any thoughts?
Karl, why don't you take that?
So the question is how to deal with when multiple jurisdictions could. I mean, most of these tax rules are domicile based, and so where you've got multiple entities in different jurisdictions, you've got multiple tax. You just go with the domicile.
So your branch in Australia would be under the IGA, right? So Chinese company has a branch in Australia, they'd follow the Australia IGA, right?
Yeah, and you've probably already got the analysis about whether local tax law applies. This is something that you've already had to think of in terms of permanent establishment and issues like that. If you've got a permanent establishment somewhere and you're being taxed under that jurisdiction, the IGA becomes the law of that jurisdiction, and so it will apply. But there are already ways to there's already analysis for which law to apply and which tax law to apply in these situations.
But
yeah,
and it does
but it's there.
Yeah, and it does get complicated. So it's something that we'd encourage people to look at. But typically, that's what will happen. I mean, your solutioning will be based regardless whether you have a branch or subsidiary in a jurisdiction. If that jurisdiction has an IGA, typically you'll follow that country's IGA. But it's something you need to think about.
Okay. Well, we're close to the top of the hour, so I'd like to thank our panelists and our attendees. Should you have any further questions, a representative will follow up with you in the coming days. And thank you all for attending.